Okay, so we're going to go ahead and get started. I want to start on time and I want to end on time. So here's the topic of today, the ultimate take you by the hand, probate asset by non-probate asset webinar that guarantees estate planning success. So here's what we're going to do for the next 30 or 40 minutes. I'm going to turn on my camera and I'm going to tell you a little bit about me, a little bit about us, but we'll spend the bulk of the time making some complicated topics very easy to understand. So there is a lot encompassed in estate planning, from taxes to government interference to making sure the right people are in charge to making sure the right people get what you have, and doing it all in a simple format with the right people in control. But one of the big topics these days is people don't want the government interfering with what they have, whether they want to eliminate that interference while they're alive or whether they want to eliminate that intrusion when they pass away that so many families have to deal with. This webinar is really all about making things simple so that you stay in control for your lifetime, and then you set things up so that the family members that you trust can handle things simply and easily without going through a lot of hassle and delay and expense when that time comes. So that's what this is about, and we're going to dig a little deeper because there's so many different types of things that people own, and they're all handled differently. So we're going to dig deep and look at all of the different kinds of assets that you may own and talk about how to set that up so it makes things easy for everybody. So that's what we're going to do. And let me tell you a little bit about us. We have a law firm and our offices are in 4 different states. It was formed 20 years ago. Best thing about our law firm is we have 9 or 10 fantastic lawyers, and every morning we collaborate on the things that we're dealing with. So if there is a unique issue, you don't get the mind of one. You get the mind of 10 different estate planning attorneys all working together to make sure you get the very best legal service that's available to you. If you want to find out what other people say about us, go to our website, rabalais.law.com, click on the reviews tab or whatever it's called, and you'll see several hundred people who have used our services and have written about it. And so I always say, if you want to find out about a business, don't ask the biased business owner, find out what other people say about it. So there's no better way to find out about our business than by reading those comments from people who have used our service. Okay, let's jump right in. A little bit about me, though. I mean, my name's Paul Rabalais. I work out of the Baton Rouge office, and I live and work out of in Baton Rouge. Born in Baton Rouge. When I was 8 years old, I received an inheritance from my grandmother. It got me through all my education. I'm thankful for it. When I was 10, my other grandparents went into a nursing home and lost everything. And so I've seen it all, and that started a very long time ago. And so now this is what we do. So let's jump right into the topic, although we'll be addressing various topics today. And so let's jump in specifically about this avoiding probate topic and what's all of that about. I was working with a couple yesterday, and they brought in their wills that they had written for them about 7 or 8 years ago. And so we came in, and the husband asked what would happen when he passed away, given the fact that he had his will in place. So the husband and wife were sitting at the table with me, and I explained to them that if he died first, then his wife would come hire our law firm or would go hire some law firm. All of his assets would be frozen, and his wife would have no access to that. She would not be able to sell the home if she wanted to. She would not be able to access the investment accounts until she hired a law firm, went through various court proceedings, and worked with lawyers and clerks of court and judges' offices to ultimately get the various court orders and judges' orders ordering that assets be transferred out of his name and perhaps into her name. She was asking how long that would take. I said it usually takes about 6 months to a year, a lot longer if there's any kind of glitches. She asked how much that might cost when he dies. I said, I don't know what it's going to cost when he dies. and there's no standard for those probate costs in our area because there's no law on it, but many families kind of are handcuffed for months or years, end up paying tens of thousands of dollars to get that done. And on top of that, I said that when she later passed away after her husband died, her children would go through that all again. So they, of course, are going to be setting things up to eliminate all of that, like so many families do, and they'll be setting things up to eliminate all those delays that occur when the assets are frozen, eliminating all those costs, which costs are common costs, are thousands of dollars of attorney's fees and court costs and bonding fees and executor fees and appraisal costs, and perhaps even other costs that are part of that court probate proceeding that's required when you pass away owning assets in your name. Just the inconvenience of it. I was dealing a couple of weeks ago when the husband passed away and the family had to roll the surviving wife in here in her wheelchair to start the probate proceedings, and she'll be coming back many times in the future, and it's just a hassle for the family to get her in here to sign and get notarized and review the various court documents that we have to go through. So that's an inconvenience, and when things don't go as planned, it gets very stressful on those surviving family members, and sometimes it harms relationships so much so that the surviving family members don't get along. So the benefits of avoiding that can be significant. Most people, some of the first words out of their mouth when they come in and we ask them what they'd like to accomplish, they say they want to make it simple. So that's what all of this is about. So let's jump in, and when we talk about avoiding probate, now I'm going to show you in just a moment how you do own certain assets that by their nature they avoid probate, but all of you out there own one or more probate assets that will have to go through the courts to be transferred when you pass away if those assets are titled in your name, whether you have a will or not. So the fast forwarding to what we do is we establish a trust, and so for the couple yesterday, I'll call it the Tim and Janelle Smith Trust, with Tim and Janelle as the trustees, so they're in charge of everything for the rest of their lifetime. They're what's called the trustees. They designated their son as the backup trustee so that when they die, their son would have access to all of the trust assets. These trust assets are for Janelle and Tim for the rest of their lifetime, so it's all for them. And then when they pass away, then it's all for the children of Janelle and Tim, with their son being in charge of that distribution. And the big benefit there is because when they pass away, when Janelle and Tim die, those assets are titled in the name of their trust, and those assets are not titled in their individual or joint names. Nothing's ever frozen, and so we don't have to go through the courts to gain access to those. So there's a number of other things we do with trusts. You know, if things might go to young children, then we say that when the children inherit, it remains in trust for them. Oftentimes when we're doing this, we want to protect the inheritance from children's past, present, or future divorces. Sometimes we want to provide for grandchildren. Sometimes children that you're leaving things to have special needs, or perhaps are just flat out irresponsible, and you don't want to dump a lump sum of assets into their name. So there's a whole bunch of related reasons why we use trusts other than avoiding probate, which is a big reason to form a trust. So that bottom line is we create that revocable living trust. Its primary purpose is to avoid the courts having to oversee the distribution of your assets, and then sometimes that trust stays in existence even after you pass away because there's some divorce protection or child or grandchild need that may warrant that trust remaining in existence after you pass away. but many trusts will end when you pass away, and then that family member that you named to be the successor trustee will be able to access and distribute the assets immediately to the beneficiaries of the trust, which are likely your children. So those are some common trust provisions, and now let's start digging into what are the typical kind of non-probate assets. So you've got non-probate assets and you've got probate assets. Non-probate assets are things that, by their nature, the way these accounts are set up, the way they permit you to designate beneficiaries, these assets, when you die, while they may be frozen temporarily, they don't have to go through lawyers and courts to be transferred to your heirs. So Tim, yesterday, he has an IRA, he has an individual retirement account, most of their money is in his IRA. And he named Janelle, his wife, as the beneficiary. So when Tim dies, Janelle won't need to come to our office, she won't need lawyers, she won't need to go through a court process. She'll merely submit Tim's death certificate to the financial institution where Tim's IRA is held, and what they'll do is they'll move it directly from Tim's IRA into Janelle's IRA. No courts, no probate, no lawyers are necessary to do that. 401k, a company retirement plan, it's really just like an IRA. It's payable to a designated beneficiary, so it's just like the IRA. Those of you who have life insurance on your life insurance paperwork, you designated beneficiaries. So the life insurance company will pay the beneficiaries directly. Annuities are just like life insurance policies, although there may be a little tax component to the annuities where life insurance goes to the beneficiaries income tax free. So those are the typical non-probate assets. So if that's what you have, then at least those things won't have to go through the courts to get transferred when you pass away. But let's talk about the various probate assets that you have, and here they are right here. The big one is the one that just about everybody has, is their home. If you own your home in your name, or if you own your home with your spouse and you pass away, or you're married and you or your spouse pass away, ain't nobody going to be selling that house until your family goes through the court process, gets all the court orders, and all those court orders then get recorded in the real estate records to take your name off of that title, to clear up the title. So virtually every time somebody dies, unless they've made some effort to eliminate the probate is necessary because they own a home. Married couples really are forced to go through it twice. You know, when the husband dies, wife can't sell anything, and so she can't mortgage it or sell it. Really not even supposed to lease it until she goes through the probate and gets that retitled. And then lo and behold, when that surviving wife passes away again, here we go. After, you know, the family was frustrated with the first one, they've got to do it again. So any other real estate also has to go through the courts to be transferred if it's in your name when you pass away. In fact, if you own any real estate that's not in your home state, not in Louisiana, then your family is not only going to have to hire our law firm here in Louisiana, but they'll also have to go hire another law firm in that other state where you own real estate. It's called an ancillary probate. So now your family is hiring two sets of lawyers, lo and behold. And then, you know, they're doing that again when the surviving spouse passes away. Families get fed up with the legal system after going through that. If you own any investment accounts, you know, there's all these investment brokerage firms out there, and you'll have accounts titled in your name. Was working with a couple. The husband and wife had a joint investment account. The husband died. The wife needed to access some of the investments to pay for the funeral. She goes to the investment company. They say, no, the entire investment account is frozen. It was in both of your names. He died. Account's frozen. Nothing you can do. Got to go through the court process. It's going to take several months, maybe a year, maybe two, to get access to that. So she was really frustrated. She didn't have a way to pay for the funeral. Sometimes people will own stock. Sometimes they have stock certificates. Sometimes they own it in street name. All that stuff gets frozen. That's a probate asset. Your CDs, your bonds, your mutual funds Timeshare interests, those are frozen when you pass away if they're in your name, even if you have a will leaving them to someone. Mineral interests, the mineral interest companies stop paying out the mineral interest or the royalty when they find out you passed away. If that was in your name, the companies need all these court orders to get things transferred. So those are the things. If you've got any of these things in your name, your family will be kind of welcomed into our legal system after you pass away in an effort to get that stuff transferred. Then these are the things that can, with an emphasis on can, avoid probate if you set them up right. Virtually everybody has a checking account. Many people have a savings account. And let's say a married couple has some bank accounts. If both of them pass away, account's frozen. So what many individuals or married couples do with bank accounts is they add a child perhaps as having signature authority on the bank accounts. That way, after mom and dad die, the child can access the account. The child can pay bills, can pay for the funeral, can close the account, divide the money up without having to go through the courts to gain access to mom or dad's bank account. Vehicles and boats here in Louisiana, as long as the paperwork's done through our office and we do it correctly, when a husband, for example, dies, if he has cars or boats in his name, he can take our paperwork that we created to the DMV or the Wildlife and Fisheries, and they'll rely on a copy of our paperwork to retitle those vehicles or boats into the name of the surviving spouse or the children or whoever it's going to. So those are the only entities that will accept a photocopy of some estate legal documents in order to transfer those after death. Everybody else needs all these court orders. So you've got some things that by their nature, they avoid probate. That's these things here. All right. So I think you haven't been seeing my screen. So let me go back through and go through that. And I think you're just now seeing my screen. So let me go through that so you'll know what's happening. I had it on the freeze thing. So my point was you have some things that avoid probate by their nature. That's these things here. IRAs, 401ks, life insurance, annuities, they're payable to designated beneficiaries that you have listed on the paperwork with those companies. You've got some things that if these are in your name, they'll go through the court process when you pass away. They'll be frozen and your family will go through the court process. They'll hire the lawyers, we'll go through the courts. It'll take months or years and tens of thousands of dollars oftentimes to gain access to that through the legal system. And then you've got some things where you can add a person as having signature authority on bank accounts to give them access, or you can take our paperwork to DMV or Wildlife and Fisheries to get cars and boats transferred without the court orders, but the paperwork has to be set up just right. All right, let me make sure we're good. What I want to do now is, if you have some questions, and we're still a few minutes away, we've got some more stuff to cover. If you have some questions, jot them down in that question box there. Love the questions, and I'll read them aloud and I'll answer them. So let's move on though. So by now, how most people feel is that if you want to make things simple for your family, if you're married, you want to make it simple for your spouse. If you're not married and you have children, or if you are married and you have children and you want to make it simple for them, you don't want your loved ones to be kind of handcuffed or pushed around by our legal system, which often happens when you pass away with things in your name. Then you should start considering creating what we call a revocable living trust. Revocable means you can change it or undo it. Living means you have set it up during your lifetime. Trust means you set up a trust. And when things are titled in the name of your trust, they don't have to go through the courts to be transferred when you pass away. In your trust, we customized who you want having access when you pass away or when you become incapable, and how you want those assets handled, who they should be distributed to, whether it's equally or in some other fashion. Does it go to children only? Does it go to grandchildren? So we structure all that and customize that in the trust instrument. Here's a good example of the difference between what we call a will plan and a trust plan. These things at the bottom, these disability documents, everybody has those. But everybody has what we call a will plan or a trust plan. The will plan is where you have your will, your powers of attorney, you leave everything in your name. It's easy to set up, you can change it. The downside of that is when you pass away, everything's frozen. Family doesn't have access to anything. Got to go through the lawyers, got to go through the courts. It's expensive, it's time consuming, it's stressful, it's a burden. It sometimes harms the remaining family relationships. So this is really the traditional old-fashioned way to get your legal affairs in order. When you think of, a lot of people when they think of estate planning, think of getting their will done. But these days, as always, the will plan and this, there's not enough information out there on this. Many people think if they have a will, then the probate or succession is not necessary. But there's nothing further from the truth. If you have a will and you have something in your name when you die, then the probate is necessary even if you have a will. So what everybody's doing these days to eliminate all those burdens is setting up their trust, set up the Sam Jones Trust. Sam's the trustee. When Sam dies, his son Fred is the trustee. And in Sam's trust, he dictated who gets Sam's assets when he dies. We do what's called the funding. Funding is simply a retitling of the assets so that Sam transfers his assets from Sam's name into the name of the Sam Jones Trust with Sam Jones as trustee. So titling it that way means when Sam dies, nothing's frozen. Sam's son is the successor trustee. He has access. He can make the distributions to the beneficiaries. You can change it, revoke it. You have complete control during your lifetime. Then the big benefit is when you pass away, there's not all that frustration that families go through when they go through the probate. So that should give you an idea of the differences, when someone either has what we call a will plan or they have a trust plan, and within that are all of the powers of attorney, the healthcare documents, the transfer documents, and then we merge into that all of the beneficiary designation stuff and the accounts. And so it's all, it all winds up, just to show you what it looks like, it all winds up with something that looks just a lot like, let me see if I can get it on the video good. Looks a lot exactly like this, with everything all tabbed and organized with all the sections and all the instructions, so that everything your family needs is in one place, and things are settled in a matter of days versus a matter of months or years. I was working with Jim about a year ago. His dad died. His dad had a trust, and I got a call the afternoon that Dad died, and Jim called me and he said, "Paul, I'm just calling to tell you my dad passed away this morning." And I had known Jim for a while, and so Jim asked me, he said, my sister is just here in town for a few days, and we wanted to see if we could come by your office tomorrow. I said, sure. They came by at 9 o'clock the next morning. And Dad's trust, Dad had two pieces of property. He had a home and he had a piece of rental property. And we had written up Dad's trust in accordance with Dad's instructions, so that when Dad died, the house was to go to the daughter and the rental property was to go to the son. Well, they came in at 9 o'clock the next morning, and by 9:15 they had signed all of the paperwork transferring the house, the home, from Dad's trust to the daughter, and the rental property from Dad's trust to the son. We got that recorded in the real estate records about an hour later. Less than 24 hours after Dad had died, Dad's estate was settled. So there was no probate, there was all that mess and all that delay. Just didn't happen because all that was just unnecessary. Dad's thing had been in his trust. None of the assets were frozen. Okay, so all of this information and really doesn't do any good unless you take the appropriate action to put it in place. So the next couple of minutes is, because estate planning is an area where people procrastinate for obvious reasons. Some people don't like thinking about the inevitable, and it's just one of those things. Sometimes life gets in the way, but it's really a critical component of what you do to make sure everything's taken care of your family. So let's go through a couple of things and show you how easy it is to get everything in place. First thing I want to do is I want to mention a guarantee of ours, because the legal industry doesn't have the best reputation, and so we've created some guarantees to eliminate the risk of doing business with us. Here's one of them right here. It's if before you sign everything, you don't go tell your friends or relatives that you work with the most professional law firm with the most courteous staff. If you didn't get the level of service that you expect, just tell somebody in our office. If you made a payment to us, we'll give it back to you. So again, starting to hear some of these things that make it easy and eliminate the risk of doing business with us. Here's our second guarantee. It's my favorite one. And so Harvard did a study. Biggest complaint about lawyers, they don't call me back. So we have our 1 business day callback guarantee. So if you put a call into our office, and if within 1 business day your call doesn't get returned, then you let somebody know. If you made a payment, we give it back to you, and we finish your legal work for free. So I'm happy to report no one's ever made a claim under our prompt callback guarantee. So anyway, you deserve excellent service. We want to provide it. Here's the steps, because a lot of people come in, they leave, they say, well, this was so easy. And so here's the steps to getting everything in order. Everybody goes through the same process. It covers everything. It starts with an initial visit. What you do is you contact our office. We have lawyers all over the state of Louisiana, and we have actually lawyers in Tennessee, North Carolina, and Texas. And but I'm here in Baton Rouge, and when you contact our office, Beth or someone will briefly find out what's on your mind, and they'll schedule a visit to come in and talk to me. And that usually lasts maybe 45 minutes or an hour. And what I'm going to do is I'm going to find out what's important to you, and then I'm going to walk you through all of the decisions that are important to you, and I'm going to walk you through all of the decisions that you need to make sure everything is in order. So decisions like, what happens when you pass away? Who do you want things to go to? Will it go just to your children? Are you married so things would need to go to your spouse? Do you want things to go to grandchildren? If things go to your children and grandchildren, can it go outright, or does it need to be managed for them? Who's going to be in charge when you pass away? Are you concerned about taxes? And if you are concerned about taxes, are we making sure we're avoiding all the estate tax, the gift tax, the capital gains tax, the property tax, the income tax? Is probate a concern? So you want to set things up to eliminate all of that. Is avoiding losing things to the nursing home a concern? Who's going to handle things when you're incapable? Who's going to make your future medical decisions if you're unable? Have you made your life support machines decision? All of those things and lots more, we walk you through all of that to make sure all of that is covered, and we do it in a very easy to understand and often sometimes kind of entertaining and fun discussion that we have to make sure it's all in order. We gather the information. Then we get to work preparing all the various legal documents, all the trusts, wills, powers of attorney, transfer documents, healthcare documents, customizing everything based on your most important decisions. Send you things to review, you come back in, you get everything signed, witnessed, notarized properly. We assemble everything in your portfolio. I showed you that a moment ago. And then really it can't and doesn't end there. To do this stuff right for your family, things have to be set up properly, and then there has to be some periodic communication over the years to make sure things stay current. Your life may change, you may change your mind about things, your family circumstances may change. From our end, we may discover some significant law change that might affect you, some new trend that becomes real important, kind of like this setting things up to avoid probate trend because the government interference is getting so difficult, so we can stay in touch over the years and maintain that relationship. So that's really the process. Come in, you visit, we walk you through it, we prepare things, you come back, get things signed, we assemble your portfolio, and we stay in touch forever. So what we've done is we've put together a description of the legal services that we provide. And so let me go through how that works. So here's where we are is, let me get this straight here. Oh. Okay, so